right, we had a immunity hearing, and what it appears to me is the individuals involved in this case were all regulars in this recording studio. Is that correct?
I wouldn't disagree with that, Your Honor.
All right, and they all knew each other. And how many people were there?
I don't know if they all knew each other, Your Honor. They knew each other by reputation. The victim had at least 4 or 5 people as part of his family or entourage that were there, as we talked about at the hearing. The defendant, according to one of the victim's witnesses, had a scruffy, homeless-looking guy standing next to him that handed him the gun. There's no other reference that the defendant had anybody else with him.
Now, for some reason, the altercation occurred when your client went into the recording studio and attacked the victim, right? We agree on that?
We do, based on the fighting words that we talked about, as far as with the racial epithets that I'm going to put 2 in your head, 1 in your eye, and then his other friend, D. Drell, that was also rapping, said, "Gun play's about to begin." That's when the fight started.
Victim was a large man.
He was 6'8", but thin, about 180, 185 at most.
All right. Now, you may have a seat. And the witnesses had to separate the 2 individuals, is that correct?
Yes, Your Honor. As we put in our order, we cited the 4 different witnesses that talked about they were separated, and 2 actually thought it was over and walked out of the building thinking the fight was over.
Now, the language of the defendant after the shooting is very damaging.
According to the victim's friends, no independent witness will verify that. It's just the victim's friends that say it. You have to understand, these are the same people that, she said they weren't even there. Then they were sort of there at the car wash, which is adjacent to this studio. Then they became inside the studio. Then they saw everything. It's a little...
Does the defendant have a record?
He has no record except for the case that we dealt with, that you gave him time served on, that we discussed at length some months ago. He had the stolen rental car issue that we talked about in Florida that he was given first offender on because he kept it too long.
All right. Well, we had the hearing on the immunity motion, and the reason I wanted to see that, review the record in its entirety, is so I would have some guidance for this hearing. Now, it appears to me that that motion fails, the immunity motion. Okay? And whether or not it's true or not, the language that's alleged when he walked out of the building, I think does not show fear. Now, my concern is intimidation of witnesses.
Yes, sir.
I'm not necessarily believing that he is going to commit another crime or that he's going to flee the jurisdiction. And based on the fact that some of these individuals knew each other, and I'm concerned about intimidation of witnesses.
If I may, Your Honor, again, I would respectfully disagree that the victim's folks and the defendant knew each other at all. They met, as far as anybody knows, for the first time on that day at the photo shoot or the recording shoot or whatever they were supposed to be doing at that location. These people all have incredibly long records. 2 of the government's own witnesses, one's wanted for some charges, the other one's in jail.
Well, that's why he's hired a fine lawyer with a fine reputation like you to try the case, because you believe that a jury's not going to believe the credibility of their witnesses. However, I don't see self-defense in the case, and that's just my review of the records, the statements, and the like. Maybe it'll be a lot different when we see the witnesses live and we can see their demeanor and their manner of testifying. So I'm going to deny the immunity motion, and I'm going to deny bond.
Okay.
Congratulations on your retirement from the military.
Thank you.
All right.
Could we talk to your clerk then about a quicker trial date, because we sort of pushed it back?
Whenever y'all want to try it, we'll do it.
And I spoke to Ms. Dunikowski. She said whatever date, as early as Monday would be fine with her.
And
Okay.
last question, Judge, for the record, you're not saying we didn't make a prima facie showing for the trial. I think when we talked in chambers...
No, wait a minute. That's a very important point.
Yeah.
I'm going to let you do it at trial,
Yes, sir.
because there's a difference in the prima facie case and by a preponderance of the evidence.
Correct.
Right?
Yes.
No. So, I mean, we don't even need to get into that for the trial because I'm going to allow it.
Okay.
And I'm going to allow it to go to a jury
Okay.
based on what I've seen.
Okay.
So I appreciate you bringing that up.
And then the last thing is, Ms. Denikovsky made some comments about the YouTube videos that the court has records of. We may need to do some evidentiary cleanup as to what the court's going to allow. Their allegation is they could be faked. Well, my point was, well, if there was a defendant, they'd be laughing me out of court if I made an idiotic comment like that. So I just want to make sure.
If there's YouTube videos that purport to be the people
Yes.
on them, the chances are I'm going to allow it.
Okay, right, because we talked about the
Right.
case law says it's weight, not admissibility. That's the issue.
That's right. I mean, the chances are I'm going to allow it.
Okay,
All right, I appreciate y'all's courtesy and professional. Have a nice day.
Thank you, Your Honor.
Thank you.
thanks, Glenn.
Thank you for helping out.
No problem, Judge.